So there was history made in the House of Delegates today. It's the first time in my memory that a National District Attorneys Association representative stood up and moved a resolution. In this case, it dealt with the accreditation of prisons and jails, and was followed by a former chair of the National Association of Criminal Defense Lawyers, who made it absolutely clear that this was the criminal justice section coming together to give the ABA something that prosecutors throughout the country, defense lawyers throughout the country could support, that was going to be an effective tool for reducing crime and promoting the reentry, successful reentry of offenders. And it was magical in part because it followed the giving of the ABA's highest medal to David Boies and Ted Olson, people who are politically apart but came together to do justice. And that's what the criminal justice section does. It does justice.
Steve, how long have you been active in the section in the House of Delegates?
I've been in the House of Delegates now, having succeeded a prosecutor, Bob Johnson. That's not right. Michael Johnson. It's right there. Michael Johnson.
Start over.
Yeah, let me start again.
So, yeah.
I got Bob Johnson on the brain.
Yeah. Steve, you've been a leader here at the ABA House of Delegates for a number of years, so you've seen things and you've got a good sense of historic developments. Tell us about how that actually happens and the process that you go through to make sure that the prosecutors and defenders around the country have their voice heard here in America, the lawyers' policymaking body.
Well, the House of Delegate representatives from the criminal justice section, all we can do is bring forward resolutions that come from the section. And the section, more in the last 5, 6, 7 years than any time before, the section tends to move by consensus. I can't remember a resolution being brought to the House of Delegates that was opposed by prosecutors and favored by defenders or vice versa. Our resolutions, not that we're unanimous all the time, but they're almost unanimous and often unanimous or with an abstention or two. And when we stand up in the House of Delegates and we say that there's really no other organization out there that does criminal justice, that brings together prosecutors, defense lawyers, judges, academics, correctional officials, and others, it's really true. And it is a moving scene in the House of Delegates when they realize that what they're getting is policy that's not coming from one side of the aisle. It's policy that is uniformly endorsed by everybody who really is a player in the criminal justice system, and I include victims in that who are represented in our section. It's a lot easier to get things through the House of Delegates when they know that the support comes from every single part of the spectrum of people who actually have a role to play in criminal justice.
We don't just deal with issues that are strictly in America's local courthouses. Tell us a little bit, if you can, about another one of the resolutions that you dealt with today, a project that you've worked on for years having to do with detainees.
One of the things that the American Bar Association does well is it deals with the military. And we have various committees, sections of the ABA that address military issues. But we don't deal with military criminal justice issues as often as we might. And the American Bar Association has taken an interest in making sure that the manual for courts martial, that it is fair and that it has the tools necessary for prosecutors to prosecute and for defense counsel to fairly defend their clients. And one of the things that we have insisted upon, and the Department of Defense has been great about since 2003, is to assure that any change in the manual for courts martial is proposed in the Federal Register, and there's an opportunity for public comment. So there's notice and public comment. This has been not true with respect to detainees in Guantanamo. Ever since the horrible events of September 11, 2001, when the United States invaded Afghanistan and later went to war in Iraq, and we began to take prisoners, and then to transfer them to Guantanamo in late 2003 or 2004. The basic rules governing Guantanamo have been largely adopted, some by statute, but many by previous administration, now the Obama administration. And the truth is that the rules end up being promulgated by the Department of Defense, sometimes with input from other branches of the executive. And there is almost no opportunity for notice, no opportunity for public comment. And there are non-governmental organizations that have complained about this. And today the ABA went on record as saying that we believe and transparency with respect to Guantanamo detainees, and that we asked that in following up on President Obama's March 7th order of this year, that if changes are going to be made for procedures and processes for handling detainees, that those proposed changes be published, notice for the public, and there be an opportunity for public comment. And this is particularly important because some of the detainees may be detained as long as the war on terror lasts, and that could be for their lifetimes.
Did you ask him about his negotiation in the House?
Steve, there are over 500 members of the House of Delegates. Certainly all the work isn't actually done from the podium. Tell us a little bit, if you can, so the members of the criminal justice section around the country who aren't here in Toronto understand how the work of the House is sometimes done in the hallways and not in the podium.
If we have time before a meeting, the annual meeting or the midwinter meeting, as a section, we carefully consider resolutions that impact criminal justice. If we have problems with those resolutions, we take them up with the groups that originated them, and we negotiate. I mean, if we're totally opposed, we make that clear. If we're not totally opposed, but we would like changes, we indicate the changes that we would like. And that happened this time. The judges proposed a revision of timetables or time standards for the handling of felony and misdemeanor criminal cases in the states. Now, these standards were adopted years ago, and they have been updated. When looking at these standards, both our prosecutors and defense counsel said that the standards indeed have to recognize prosecutorial and defense counsel workloads, that not all cases can accommodate these time standards, that particularly in these days where there's underfunding of courts, underfunding of prosecutors, underfunding of defender organizations, that it may very well be that timetables or time standards that would work well in an ideally funded world will not work, and the standards have to recognize those. So we went to the judges who had proposed the time standards, and we said, we know that you don't want to see injustice. You know that you don't want to force prosecutors to compromise public safety. You don't want to force defenders to engage in ineffective assistance of counsel and prolong litigation forever as their challenges to convictions. What you want is justice. And so what we said is we want to recognize the importance of time standards, and we did that. But in the implementation, to have you recognize that there are burdens, caseload burdens, and other burdens that arise when prosecutors and defense lawyers are handling cases, and that it's very important that the rush to a disposition of a case not compromise justice. And ultimately they agreed, and it's a pretty hard proposition to disagree with.
Give us a summary of what happened at the House of Delegates. And don't say today, just say at the House of Delegates.
Oops, there you go. Steve, give us a summary of the events at the House of Delegates in Toronto, Canada.
We had 5 resolutions the criminal justice section put forward. The first dealt with asking the United States Sentencing Commission to take a look at child pornography cases and to examine whether or not the penalties that are prescribed for the various offenses are appropriate, and to look at the offenses, the victims, the offenders, and the way in which technology gets used, all the relevant factors, and to see whether or not the penalties are appropriate. Second, we asked, and the ABA approved, the House of Delegates, we asked to have accreditation agencies take a very careful look at jails and prisons and to adopt accreditation policies that really assured the highest level of scrutiny of jails and prisons. Third, we adopted a resolution that had to do with assuring that jails and correctional facilities had appropriate policies dealing with women and in various different ways. Fourth, we adopted a policy that essentially said the ABA is on record in recommending that prosecutors turn over what we call Brady and Giglio material to defense lawyers in a timely way before a trial, and that prosecutors turn over Brady material and Giglio material that sort of rises to the level of Brady prior to the acceptance of a guilty plea. The idea is to make the Supreme Court's exculpatory evidence cases meaningful, and that resolution, I think, went a long way to do that. And lastly, we adopted a policy of transparency for Guantanamo detainees, saying that before President Obama's March 7th, 2011 declaration or executive order with respect to procedures, before that's changed, there should be notice of proposed changes in policies and also an opportunity for public comment.
Steve, thanks for joining us on Case Notes and for being our guest here today.